for your presentation and kind words. So I'm going to focus on mainly on how the data protection legal framework aims to serve as an instrument to comprehensively address all of the different risks and harms that derive from the use of automated systems. I'm mainly going to focus on algorithmic discrimination, how the data protection legal framework, the EU data protection legal framework, aims to prevent algorithmic discrimination, deal with instances of algorithmic discrimination, but I'll also refer to the other risks generated by these systems. So algorithmic discrimination is a phenomenon that must be analyzed from a double perspective. It is a two-pronged phenomenon. On the one hand, it is another expression of discrimination, which is precisely what Rafael mainly focused on in her presentation. It is another expression of the way in which certain members of certain groups in society have been historically subjected to social disadvantage and are still subjected to instances of disadvantage. And on the other hand, algorithmic discrimination is also an expression of one of the multiple risks, one of the multiple harms and damages that are caused, that are generated by the use of automated processing systems. So over the past few years, we've seen how academia, public institutions, social activists have brought attention to the different problems that are generated by the growing use of automated decision-making systems and the growing complexity of these systems. So, for instance, as Rafael mentioned, these systems lack transparency due to, in part, to their complexity in some cases, but also in many other cases due to the refusal on the part of organizations, of the organizations that are using these systems, to disclose their content. This also leads to problems when it comes to accountability. And obviously, all of these issues are closely related to instances of algorithmic discrimination. It is very difficult to detect cases of algorithmic discrimination. It is very difficult to prove them. In addition, when it comes to public decision making, we've also seen how many public institutions who are using these systems are refusing to disclose their content or are using these systems in a way that's contrary to the basic principles upon which these institutions and the way they operate should be based. We've also seen how individuals who are subjected to automated decision making in some cases lack due process rights. They are not able to challenge these decisions, or in some cases, once they are able to challenge them, the damage has already been caused and is irreversible. These systems can also be used in order to manipulate individuals and generate problems, generate risks regarding their dignity, autonomy, their individuality, their freedom. And perhaps probably the most significant, rather than the most significant, the most obvious risk, the most obvious damages caused by these systems are the damages that are caused to the rights to privacy and personal data protection. Because these systems, after all, work by processing huge amounts of information that in many cases are information that contains personal data. So as a result of this situation, the main legal framework that currently is in force, that is applicable to instances of automated processing, and that aims to jointly address the different risks and harms generated by these systems, is the EU Personal Data Protection Legal Framework. So on the one hand, this legal framework is mainly made up of two legal instruments. On the one hand, we have the GDPR, which establishes a sort of collaborative governance system by establishing some command and control provisions and other provisions that tend more towards co-regulatory or self-regulation strategies. And then we have the directive on data protection in law enforcement. So these instruments are based on the principles contained in Articles 5 of the GDPR and 4 of the directive, which include the principles of lawfulness, fairness, transparency, and purpose limitation, etc. And upon these principles, they build three building blocks. Which include technological due process rights, accountability or general oversight mechanisms, and then processing prohibitions, which is the building block that I will be mostly focusing on, as this is the building block that mostly focuses on preventing and dealing with instances of discrimination. So regarding the technological due process rights block, these rights include the rights to information, to access the data, to get an explanation regarding the underlying logic of the system, to request their rectification, delete their information, to object to the processing, to obtain human intervention, and so on. And with regard to the general control and accountability mechanisms, we have data protection impact assessments, which must especially be carried out when the processing generates significant risks and harms for the fundamental rights of individuals. We also have a system of sanctions that is set up, a system of independent data protection authorities. And then in the GDPR exclusively, we have these provisions that are more aimed as a system of co-regulation or of self-regulation that include codes of conduct and certification mechanisms. So when it comes to the GDPR and the directive for personal data protection in law enforcement, both instruments convey their aim to enact, to prevent, to deal with instances of algorithmic discrimination. So, for example, in some of the recitals of both legal instruments, we can see how discrimination as one of the risks generated by data processing is mentioned. And for example, in recital 85 of the GDPR and 61 of the directive, we can also see how discrimination is recognized as one of the possible damages that can result from personal data breaches. However, the most important recital and the one which sets out the basis upon which the anti-discrimination strategy of the GDPR and of the directive for data protection in law enforcement is recital 71 of the GDPR mainly. So this recital on the one hand establishes the recommendation or obligation of controllers to implement technical and organizational measures to prevent inter alia discriminatory effects, and establishes the fact that automated decision-making and profiling based on special categories of personal data should be allowed only under specific conditions. So this idea is the main idea upon which the anti-discrimination strategy contained in these data protection instruments is based. This anti-discrimination strategy is mainly contained in Articles 9 of the GDPR and Article 10 of the directive, and is based on the notion of anti-classification. So the idea of anti-classification is a concept that has mainly been developed by the US legal scholarship, and it is based on the notion of blindness. So on the idea that if a decision maker does not have access to an individual's membership to an especially protected group, they won't be able to make a discriminatory decision based on said membership to this group. So Article 9 of the GDPR establishes the prohibition to process personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, etc. And Article 10 of the directive establishes a very similar provision. So the idea here is mainly to prevent instances of direct discrimination, because direct discrimination occurs when a decision is made based on on one of the protected grounds contained in the different non-discrimination clauses contained in constitutions. And as you see, although these categories of data don't completely overlap, they do significantly overlap with the specially protected grounds contained in these non-discrimination clauses. In addition, Article 22 of the GDPR, which establishes the prohibition to base decisions solely on automated decision-making, on automated processing, including profiling, establishes an especially extensive prohibition when it comes to the processing of special categories of data, so of the categories of data contained in Article 9 of the GDPR. And Article 11 establishes the prohibition to carry out profiling that results in discrimination against natural persons on the basis of special categories of personal data. Obviously, this provision is redundant with non-discrimination clauses contained in the EU legal framework for the protection of equality and non-discrimination, but it is relevant to the extent that it sets out anti-discrimination as one of the objectives to be attained by this data protection legal framework. So, as I said at the beginning, the EU data protection legal framework aims to comprehensively address all of the, or many of the risks and harms that are derived from the growing use of automated decision-making systems. And these risks and harms are closely related to each other. However, due to the fact that this legal framework is essentially built from the idea of privacy and of personal data protection, it largely fails to accomplish this objective of jointly addressing all of the risks and harms that are generated by these systems. Which is the reason why the EU is currently developing other legal mechanisms, a new legal framework to address the risks and harms generated by these systems. However, over the past few years, we've seen how many scholars and public institutions have relied a lot on this legal regime in order to deal with these risks and harms, which has to a large extent proven ineffective when, for example, dealing with cases of anonymized data, because, for example, anonymized data is not included under the scope of the personal data protection legal framework, obviously. However, anonymized data sets can also lead to instances of discrimination because, anonymized data sets can sometimes include data that can be re-identified. So the individuals whose data is contained in these data sets can be re-identified. And B, because these data sets can be used to construct profiles which lead to the perpetuation of certain discriminatory stereotypes that are then applied to identified persons. In addition, this legal framework focuses on the input data and not on the output data, which generates special problems, especially when we're speaking of instances of discrimination, because the instances of discrimination occur once the data has been processed in many cases. And in addition, this legal framework is mainly based on the notion of informational self-determination. So the most important provisions contained in the GDPR are those that confirm the technological due process block. And these provisions are based on the notion that if individuals have a series of rights, have a series of tools to defend their positions, to defend, to challenge the automated decisions that affect them, it will be possible to make these systems accountable and for these individuals to properly defend their rights. However, in many cases, individuals are not even aware of the fact that they are being targeted by these types of processes. They are not aware of the real risks that sharing personal data entails. And in addition, this framework, this informational self-determination approach, places a series of burdens that especially vulnerable populations are not able to properly deal with. In addition, the accountability system, even DPIAs, which are in theory mandatory in certain cases, are not being carried out. So, for example, in the Dutch Siri case, one of the DPIAs that should have been carried out was not developed. And we're speaking of public institutions here. It was the Dutch government that should have carried the data protection impact assessment. So if public institutions are not carrying out these obligations, let's not speak of what the situation will be when it comes to private organizations, obviously. And finally, the reliance on the GDPR, which is an instrument that is actually mainly meant to deal with the private use of automated decision making or data processing, has led to public sector institutions to avoid disclosing, in many cases, the content of the decisions, and to the principles that should be applied and the especially strong transparency requirements that should be applied to public institutions to be circumvented as a result of relying on the provisions contained in the GDPR, or simply as a result of the non-existence of an actual system for the application of for the regulation of public automated decision making. Finally, specifically when it comes to algorithmic discrimination, this legal framework does not properly prevent instances of algorithmic discrimination, does not properly deal with instances of algorithmic discrimination. First of all, anti-classification, so preventing algorithmic systems from accessing automated systems from accessing special categories of data does not prevent indirect algorithmic discrimination, because membership to a specially vulnerable group, for example, can still be inferred from other pieces of data. So, for example, Article 9 of the GDPR establishes the prohibition to process data that reveals, for example, ethnic origin and so on. So this could be interpreted as the objective of the GDPR to also prevent instances of indirect algorithmic discrimination. However, it is almost impossible to eliminate all data that reveals the membership of a person to a specially vulnerable group, to a historically disadvantaged group. In addition, the impossibility of processing these categories of data also hinders the possibility of identifying cases of discrimination. There are a series of articles of papers that have done research in this sense, and have concluded that automated systems that discriminate, so instances of algorithmic discrimination, are much more easily identified when the system actually processes an individual's membership to a specially protected group. And finally, in addition, anti-classification strategies can reinforce group disadvantage, because the specificities that characterize historically disadvantaged groups are not taken into consideration, which can help to reinforce the system. So it can help the system to base its decisions on the prototypical individual, which is basically the white heterosexual male, without taking into consideration the specificities that characterize historically disadvantaged groups. On a final and more positive note, however, the data protection legal framework can also help to solve some of the gaps that appear in the anti-discrimination framework, to the extent that the framework for the protection, the legal framework for the protection of equality and non-discrimination, mainly focuses on, is mainly made up of ex post mechanisms, ex post reaction mechanisms, and through the technological due process rights, and through the mandatory introduction of prevention measures that is set out by the GDPR and by the Directive for Data Protection and Law Enforcement, it is also possible to a certain extent if applied jointly, to deal with some of the gaps, to fill in some of the gaps that are left by the equality and non-discrimination framework. So until the new AI regulation is enforced, and until the gaps that are being pointed out with regard to the equality and non-discrimination framework, it may be possible to jointly address these two legal frameworks, to jointly use them in order to fill in some of the gaps that both of them have. Thank you very much.
Thank you very much for your presentation. I mean, that was fast. That was real fast. If any of you have any questions that want to pose to Alba, or otherwise, if we have something on the chat, which I don't think, I mean, it's your moment. Feel free to participate. You women up there, I mean, we're being discriminated here. Don't you have any questions? No? Yes, thank you.
Thanks a lot, Alba, for your very interesting presentation. I just had a quick comment or question. What do you think about have you heard about the right to reasonable inferences? There's an article by Sarah Wachter from Oxford and her colleague suggesting that as we do not know how the big tech companies actually profile us and make inferences about us, that we should have a right, I mean, that data subjects should have a right to reasonable inferences, in a sense that would be able to know how they've been classified and how they've been how they might have been discriminated against. And I don't know how you fit this into the dual framework between data protection and non-discrimination.
Yes, so the right to reasonable inferences is also has a lot to do with the right to understandable inferences. So to the extent that algorithmic systems make inferences that may not make sense, will probably not make sense for us. And actually, I think the debate regarding this issue is very interesting, because there are some scholars that pose that if we argue that a right to get reasonable inferences should be defended, then we are preventing technological development from being carried out, in the sense that we may not understand the logic underlying algorithmic systems, but these are still accurate. However, to be honest, I think considering the extent to which technological development is taking place and the risks and harms that are being caused and the amount of vulnerable populations that are being subjected to automated decision making, I do think the right to reasonable inferences should be recognized. But I don't think it fits right now in the current legal framework. So that right doesn't actually exist, obviously. And I don't know if you've read the proposal for the new AI regulation, but it doesn't, it prioritizes technological development over individuals actually understanding why companies or public institutions are making the decisions they are making based on algorithms. So, yeah.
Okay.
Hi, Alba. Thank you for your presentation. I have a question because, for example, we hear a lot of the white book of AI, and we hear about the proposal of the reglement or the AI in the European Union. But, for example, I know that Spain is working on the chapters of the digital rights, and this is a proposal that is sent to, I think, to the Parliament, to the European Parliament. But, for example, why, or what do you think about the fact that this Charter of Digital Rights don't have the same popularity as the other reglement and the other proposal have. And for example, I think inside this Charter of Digital Rights is they're talking about this algorithm discrimination rights, because we have to know, we have the right to be to the explication, to be the transparency about the algorithm deciding our life, our jobs, our relationships, even with Tinder, you know. So what do you think about this this concrete proposal of the Charter of the Digital Rights? Thank you.
Well, the charter that has been developed in Spain is more a declaration of intentions. It's not a mandatory legal instrument, which is probably why it is so comprehensive, and it is actually something that should be taken into consideration when developing mandatory legal instruments. But I'm not very optimistic about the fact that that would be taken into account. And to that extent, if you compare, for example, the Charter with the proposal for the new AI regulation, the Charter goes much further in, for example, establishing protections in the front of algorithmic discrimination, transparency, and so on.